Good evening, everyone. Good evening. I'd like to thank everyone for coming out tonight, and I'd also like to thank our panelists. We're very excited to have you all here. I'd like to introduce tonight's moderator, host of the McCarty show, McCarty.
Good evening, ladies and gentlemen. It's a pleasure to be here tonight. I'm honored by the Mackinac Center for Public Policy to invite me for tonight's event. Let me introduce to you this evening our panelists, starting to my far left, Miriam Aukerman, ACLU staff attorney. Luce, Herrmann, she is general counsel for the Michigan Press Association, here just to my left. And in the middle, Reitz, executive vice president, Mackinac Center for Public Policy. As we get started, we'll start with Ms. Aukerman. Opening remarks for each about tonight's subject when we discuss FOIA.
Thank you. It's great to be here. Thank you all for coming out this evening. It's always great for us to be at the same table. We don't always agree on everything, but we actually agree on many more things than you would think, and one of those is open government. And that's particularly true as we see mounting privacy concerns, technological changes, and a lot of government intrusion into our private lives. Judge Damon Keith wrote in a famous ACLU case 5 words that I think summarize the ACLU's position about open government, and that is, democracies die behind closed doors, and they do. If you don't know what your government is doing, you can't hold your government accountable. And whatever your political opinions are about what government should be doing, we need to know what it is doing to hold it accountable. So we're very pleased to be here tonight to talk about the Freedom of Information Act and how we can use that and improve that to make sure that our government is accountable.
Well, good evening, everyone. Thank you for joining us and taking time out of your summer evening to be here and to learn more about this subject. Really pleased to be here with the ACLU and the Michigan Press Association. We started talking about the idea of hosting town halls around the state. This is 3rd of 4 to talk about FOIA, the Freedom of Information Act, and access to public records, access to public meetings. And we wanted to do it for a couple of reasons. One was to raise the profile of those issues in communities and help folks who might not necessarily hear about those things get more of an educated view on how to use those tools to keep their governments accountable, government officials, elected servants. And the other idea was to give some momentum behind a couple of bills that are going through the legislature. And we'll talk more about those later, but we certainly do appreciate your time here tonight. I'm going to read a quote. Since we're reading quotes, I've got a good one too. Not quite as pithy, but it was James Madison, so we'll give him a pass. He said, more than 200 years ago, a popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. In other words, as Miriam said, the way for us to keep an eye on our government and to hold them accountable is to access records that tell us what they're doing, the decisions that we're making, and to be able to observe the kinds of things that they're doing in public meetings. So we're very happy that you're here tonight, and we're going to be talking about some interesting things, and we hope you'll have lots of questions. Thank you.
Good evening, everyone, and yes, I will continue the quote fest. I'm actually going to follow up on Miriam's quote from Judge Damon Keith and go on to quote for a little bit further from his opinion. He did obviously say democracies die behind closed doors. And when government begins closing doors, they are selecting and controlling the information that we receive that rightly belongs to us. Selective information, said Judge Keith, is misinformation. And the framers of our Constitution, and the First Amendment in particular, did not trust government to separate the true from the false for us. they protected us against secret government. It's ironic, to say the least, that as you've heard about in the media over the last several months, the government thinks that it's okay to monitor citizens in all sorts of ways, electronically and otherwise, using our taxpayer dollars. But all too frequently, the government doesn't think that they should be accountable to us and have to give us information about how they're spending our dollars and what they're doing and informing us about their decisions. One of the things that hopefully we will accomplish tonight is talk about some of the reasons for that and what you can do as citizens to help right the ship, I guess is what I'll say, and demand accountability from your government, and hopefully also give you some tools to use to get more access to information. So we encourage questions at the end. We have some lively discussions, so please don't hesitate.
Thank you all. This morning I had a chance to sort of take a dry run at being moderator tonight. I interviewed on the radio show a member of the press. Mike was on the show and also did talk to a state Supreme Court justice with regards to FOIA. And we had quite the interesting conversations. And I think for Ben Gose, who's the editor of the Boyne City Gazette, it was more of a cathartic experience for him, because I opened up the questioning with him and he wouldn't stop talking for quite some time. He has had a lot of experience with trying to get information from the government. He framed it as being different from municipality to municipality, depending on who he was working with. Let me ask you, and we'll start to my direct left, how, in your estimation, does FOIA work? And what is it supposed to do, and how close are we to achieving that goal? To ask sort of a later question off the bat, but what is FOIA supposed to be doing?
Well, the Freedom of Information Act, FOIA, and the Open Meetings Act, OMA or OMA, together provide mechanisms for citizens to know what their government's doing. FOIA goes to records, the Open Meetings Act goes to actions, and they work together. Under the Open Meetings Act, all decisions, all of them have to be made at a public meeting where we have the right to be present. And all deliberations have to be made at a public meeting unless one of the few narrow exceptions applies. So the idea would be, for example, we'll be talking about this more, that when your school board, for example, is hiring someone to be the superintendent of schools, right? You can use the Freedom of Information Act to find out about that person, their qualifications, their work experience. And then you have the opportunity to go to the school board meeting and see the finalists interviewed, and hopefully also have an opportunity to ask your own questions, so that you see what the government is doing at the meetings and you understand the underlying actions of the government. In addition, there are some very practical things that happen with FOIA. You know, you want to know who owned the parcel before you, right? When you're buying property, that's FOIA. You're going and looking at records for the Register of Deeds. If you want to know what the taxes were. So it provides very basic information to inform you not only of what the government's doing, but of everyday decisions that you may need to make.
I'll read from the Freedom of Information Act. This is the public policy statement from that law, and it says, it's the public policy of this state that all persons, except for a couple, are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and public employees, consistent with this act. People shall, and this is what FOIA is for, the people shall be informed so that they may fully participate in the democratic process. Government decisions are often reflected in documents and often made in public meetings, and these laws, the FOIA law and the OMA law, are intended to give us a window into that decision-making process. And the way the law works, and Robin said this, and I think it's an important point, the idea with FOIA is that records are supposed to be, public records are supposed to be turned over to requesters. That's the default. There are some exemptions in the law, and so a government agency can say, well, we're not going to turn this record over or a portion of this record over because this exemption allows us to. But it has to be stated in law. They can't just make up a reason. They can't tell you that they don't want to give you a record because they don't like who you are or what you might do with that record. The default is disclosure. And we'll probably get into some more practical how-tos, but filing a records request, just the very basic idea, is pretty simple. It can be an email, it can be a fax, it can be a written letter. You file a request with a government agency asking for a record. And you don't have to name the record specifically. You can say, I'm looking for records related to X subject. And the idea is that the agency then needs to get those records for you and turn them over.
So the concept is very simple. It's like we're saying, records are public, you request them, government turns them over. In practice, that works differently at different levels. So you might be an individual homeowner, you're concerned, you've heard rumors that the government, your municipality is going to be building a street through, in your area, through, in the middle of your farmland. You can FOIA information about that, so you can find out what's going on that affects you as an individual homeowner, individual citizen. Or maybe you've heard rumors about the water quality or something like that. You can request information about that. FOIA is used by advocacy organizations like the ACLU, where we're trying to find out about what government is doing on a particular issue. So we'll send FOIA requests. It's used a great deal by the press, so investigative reporters, other reporters they'll be trying to find out what happened on a particular issue, so they'll investigate using FOIA. So it's used by many, many different organizations, individuals for lots of different purposes, even though the principle is the same, that we should all have access to government records and government information. The comment about municipalities being varying by municipalities rings completely true in our experience. Just two examples of that. We did a couple years ago, we sent a record request. We were interested in the issue of suspensions and expulsions by school systems and how they affect students by race. And the report that we ultimately produced showed really very, very highly disproportionate suspensions and expulsions for children of color. But we started that research by sending for a request to school districts across the state. 60% of school districts just didn't even respond. Right? They didn't even bother to turn over the data. Right? Another example, we were interested in looking at how local governments are involved in immigration enforcement. So we sent FOIAs to a number of different sheriff's departments. There was one sheriff's department that sent us about 1,000 pages. The rest of them sent us about 2 or 3. Right? So, and you gotta imagine that the ones that sent us 2 or 3, they had probably 1,000. They didn't turn them over. Right? So there's a huge variation in how municipalities, state government, federal government responds to FOIA requests.
Also this morning we discussed, because of the changing landscape where it used to be television stations, newspapers, and magazines solely, with the advent of what has exploded as the internet, we have bloggers, we have different people involved in reporting. Then the question becomes, why should the Freedom of Information Act not be free? In other words, Grand Traverse law enforcement, if you go get a mugshot, you have to pay $5. Now, while other areas in Michigan will go ahead and send you mugshots or information without even being requested, it can be onerous for those smaller guys out there. And what recourse do they have when requesting information? Point City Gazette quoted me a price, they pay $1 a page for anything that they request. Let's start down the far left. Where do we, I meant the far left of the table, by the way. It's not a geopolitical statement of any kind. Where are we on making it more accessible if it is freedom of information? and yet we have a cost factor involved.
Well, the cost factor is very, very real. And to tell you one story, we spent about 3 years trying to get records from the Michigan State Police regarding cell phone extraction technology. So basically, we had heard about the fact that the Michigan State Police had this technology that allowed them essentially to, without your knowledge, if they look at your cell phone, extract a bunch of information. And, we didn't know exactly what was going on. We wanted to find out information about that. And so they said, yeah, we'll turn it over, but you have to pay us $544,680. Well, we weren't able to do that. So the cost factor is very, very real. I mean, we had one of my cases recently. We were, and actually we filed a litigation around this issue, but there's an issue in the city of Grand Rapids where business owners signed secret letters that essentially allow the police to arrest anybody on their property. We wanted to find out which businesses had signed these letters, make that information public, figure out what was going on, and we sent a Freedom of Information Act request to get that information. They said, well, we'll turn it over to you, but you've got to first deposit $4,000. We're not going to tell you how much it's going to cost to search for this, but a good faith $4,000 deposit at the outset, and then we'll see how much how much the total bill is. Well, we weren't able to do that either. I mean, these expenses are very, very real, and even organizations that have some, we do pay for FOIA requests with some frequency because we make them, and they do cost money to get them back. But the costs are exorbitant in many cases, and government uses that cost as a way to keep information. Another example of that is when I first started doing this work, we used to be able to get a lot of law enforcement agencies would turn over incident reports to you. You have to pay for them, but they would turn them over unredacted. Now, what I get back a lot is, well, we have to redact them, and that's going to take staff time, and that's why, for example, the example that I gave in Grand Rapids, that's why it's going to cost so much money. It's not that hard to photocopy all this stuff, but we got to have a staff person go through and redact everything and take all this information out, and so that's going to be expensive. And so the combination of that makes it very expensive. I don't have any good news to share on that, unfortunately.
Let me just, if I may, just add on to a quick question before Robin responds. Then because you are here representing the Michigan Press Association, obviously you have your general counsel, the Michigan Press Association does have, I would think, a pretty big stick. And is there any case in which the Michigan Press Association would not be able to make a FOIA request based on cost?
Absolutely. And the Michigan Press Association itself typically isn't issuing FOIA requests, but our 300+ members are. And they range from 2 or 3 person operations to the Free Press News, things like that. And very frequently, they are priced out of getting information. That's absolutely true. Now, when you ask that, why isn't it free? I have an answer for you that's not a real good answer, but it reflects something that I've heard a lot from public officials. They do not view the Freedom of Information Act as a core government service. They don't look at it the way that they look at police and fire. Even there now, in some places, they're trying to ding you for, charge you a fee for this or that or the other, but they don't view it as a core government function. They see it as bureaucracy. They don't view a taxpayer requesting a tax record any differently than the State Department of Treasury requiring them to send copies of all their tax records. That's why it's not free, because they see it as a non-core function, and it's bureaucracy, and it's a burden to them, and it's not very important. Why do they think that? Because we're not good at telling them, yes, it is a core government function, and we expect you to provide this information, which, by the way, we already paid you to gather,
Yes.
right? Because we're paying your salaries.
So Michael, if you take both of those responses, and let me add on just another layer of the question, where are we on this, and what does the future look like to making that part of the equation more accessible for all of us?
Well, the future is, I think, good, but I'll just echo quickly what Miriam and Robin said about the cost. the Mackinac Center filed a records request with Michigan State Police. You talked about the state police. I hope there are no state troopers on my route home tonight, but we'll pick on them a little bit. We filed a records request with the state police, and the response we got back was the request would cost us $6.8 million. And that was simply something that we were not going to pay. You know, it was well beyond our annual budget, and contrary to popular opinion, we didn't have unlimited resources to go and pay those kinds of bills. So we weren't able to get those records. What agencies can charge you for, there's two different categories. One is just a copying cost. If you want 5 records, they can charge you for the cost of copying those records to hand them to you. They can also charge what we've called search fees, which is finding the records and gathering them together and excising out information that can't be turned over. And those fees can add up very, very quickly. So I think the reason I said the future looks good is that there is legislation to deal with this. Representative Shirkey in the House has introduced a bill, it's HB 4001, and that would require agencies to cap the cost that they can charge for copying fees. I think it's 10 cents a page, right? And 10 cents a page, it's about right. Maybe it's a little bit exorbitant when you can get it for 2 at Kinko's, but fine, it's better than $1 a page.
Or $2.25.
Or $2.25, yeah. And then the other component of that bill is that it does put some limitations on how the agency can do the search fees. And if they don't respond in a timely way, then the amount of fees that they can recover from a requester starts to diminish over time. So, those bills aren't moving quickly through the legislature. The fact that they've gotten introduced and have had hearings on them, there seems to be better momentum than what we've seen in Lansing in previous years.
I find the idea of redacting documents interesting, since you're looking for information, and once you get the information is blocked out from you. There are also ways that governmental bodies can either drag their feet or rope it over a little bit, and just simply either not reply or take such a long time that it becomes almost useless to whomever is requesting the information. From the ACLU's perspective, it will come this way, is what's recourse? Obviously, we're talking about some pretty big organizations here. For the smaller guys, like for example, me and my little radio show, I don't know if I've got a whole lot of time or resources to dedicate to chasing them down, but I don't even know how to do that.
Well, there are a couple of answers to that. One is that you can litigate if government refuses to turn over information. You can litigate that. I had a FOIA case that involved Immigrations and Customs Enforcement and abuses by that agency. We brought a lawsuit. They turned over the records. It took an enormous amount of time to litigate that. They said, well, we were going to turn over the records anyway, and so we didn't end up, getting the cost back that we invested hundreds of hours of legal time into actually forcing them to turn over documents. And so it can be extremely frustrating, even for an organization that has the resources of the ACLU, because you don't recoup what the effort that goes into that. You can get some kinds of records through discovery in litigation. So for example, the example I gave before about these sort of secret letters that are used by the Grand Rapids Police Department, we've now sued the city of Grand Rapids on that issue, and they're going to have to turn that over in litigation. We might have been able to resolve all of this without a lawsuit if they actually just turned it over under the Freedom of Information Act to begin with. So there are some options, but even for organizations that have resources, it's very, very difficult. And so I think really and I say this as a lawyer, often litigation is not the right strategy. We really feel like here the answer is legislative. The answer is, and public education, the answer is for Lansing to pass legislation that improves the Freedom of Information Act, caps costs, makes government more responsible for turning things over, clarifies some of the exemptions that are really being widely used. Use that, and then use public education to educate both the public about access through FOIA and municipalities, government about their responsibilities, and really change the public debate so that the perception is, so the understanding is that really these are our documents. The government can't be keeping them from us because they belong to us. This is our government, these are our people, this is our paperwork.
Can you pull the microphone closer to you?
Sure, sorry about that.
And I think perhaps some of the frustration of those either in the media or just the general public feel that the government is not responsive enough, and that there has been this culture of, you work for us and not the other way around. In other words, we are no longer the people, and we are being bossed around by those in office. For the Michigan Press Association, does that ring true to you at all? And how do you go about combating that notion that it is an adversarial relationship between press and government, and how is there any way to work through that so maybe litigation isn't possible?
Well, I think to some degree you can do that. I mean, I actually speak to public bodies as well, and I always counsel my clients to try and have a dialogue with the person to whom the FOIA coordinator, whoever they sent the request to, or someone within the office, because public bodies can sometimes complain about they don't know what the person's looking for. And my response is have a dialogue. Unfortunately, some municipalities tell their people, you will not have a conversation with anyone about it. You decide what they want, you give it to them, and that's it. That doesn't make sense. A dialogue is always the first step. But as a practical matter, you have public bodies that either are playing a game, right, because they know the obstacles to enforcement, or they don't know, they don't understand. And with term limits and all that sort of thing, and people, local community people, my grandpa, who was a farmer, there's no way if he'd sat on the school board, he knew anything about Freedom of Information Act or Open Meetings Act. People need to be trained, and we need to promote that sort of training. But there is one other bill that's under consideration right now. It's 4314, which would establish a FOIA commission. And the idea behind that is you would have essentially an administrative group so that people could take their FOIA disputes to the administrative group, right, who's going to issue reports and make some decisions as a step less than litigation. Because one of the other issues with litigation that we know as lawyers as a practical matter, if I'm in a local county and I'm in front of a judge and I actually win my FOIA suit or a portion of it and I want attorney's fees, he's thinking he knows or she knows what that budget is. And they know that that money may affect their workings too, right? Because there's only so much money to go around. So they're not likely to give us everything that we're entitled to, right? So all of those things really work together.
And Michael, I think we talked on the phone when we talked on the radio this morning with regards to there seems to be more and more effort, at least in Grand Traverse County, on Facebook, Grand Traverse 911, where they will list what's going on and give you information on a fairly limited basis. But because of the internet, because of things like social media, it would seem to be easier for governmental entities to make their information with regards to, say, bug shots or other information, pictures, whatnot, available on the internet. I know I've done that with the city commission to go over their minutes for months and months. They may be lagging in time that they get it up there, but it is there to review. So perhaps it's more of an issue to some degree that people just don't know really where to look.
Yeah, I think a lot of issues where, there are probably elected officials or public employees here in the room, and so we're not targeting our complaints at you. It's just that we're grizzled and tired. I think there are a lot of situations where when agencies complain about the cost of complying with FOIA, it's more of a records management problem than a compliance problem. And what I mean by that is if they had a way of indexing and archiving and publishing records in a way that were accessible and searchable by individuals, there would be fewer complaints. I mean, imagine if you could file a records request with your school district for the minutes of the last board meeting and they shot you back a link that took you to a PDF, and that's all they had to do. There's no copying costs, there's no search fees, the requester gets their response almost immediately, and it improves the dialogue and the feeling of goodwill among citizens and their public officials. So I think taking advantage of these emerging technologies is a critical way of improving the open government community.
I'm interested, we'll start down once again to the far left. If there is a notion that governmental entities are interested in embracing new technology, not only to make it easier on themselves, but cutting their own costs, or would they rather prefer to be sort of behind that wall where they say, well, we don't have the staff, it's too costly, we'll get to it when we can. Is there any indication that there is an embracing going on of new technology?
You know, I think that probably varies a lot by municipality and by the government that you're talking about. There's certainly, I would say as a generalization, much more information available online about what government is doing. I mean, you can see for many counties, school boards, you can see, I mean, we very often get complaints about, for example, things that happen at a school board meeting, a graduation, those kinds of things. We can all, my system will go on and she'll find the, online video and she'll watch it and she'll see if there's a, if there's a problem that we need to be involved in. And so same thing, we can get minutes. There's lots of information. Not, again, it's not consistent, but there's also a real move towards dashboards, sort of, kind of bullet point information about how government services are doing. You see this in particular with the courts. And I think in terms of sort of the base level information, minutes, that kind of thing, a lot of that has now become accessible. What remains, I think, difficult to access are sort of the sort of further back records about, give you an example. There's a jail that we're looking at that has some very significant health concerns for the population and cross-gender viewing by male guards of female inmates and those kinds of things. You can find a lot of information about the jail facility, that kind of thing, in online. What you can't find, obviously, are the sort of individual medical complaints, those kinds of things, and a lot of that stuff is even not available under FOIA. So there are layers of information. Some of it is becoming more available, but some of it is not and probably never will be.
Let's talk a little bit about the tips and trick strategies. For those of us who, because I'm in the position myself, ready to embrace a FOIA application, but really not quite sure what the best strategies are. I have a friend who used to work in law enforcement downstate in the records division and had to go to seminars with regards to FOIA on what to do and how it all works. And the advice she gave me, which I found funny, was to be as broad as possible and specific as possible all at the same time, which I found to be clearly to the government's liking. For the Michigan Press Association, first, what are some of the tools or tips to best serve someone looking for information?
Well, there are a lot of them. I won't list all of them. One that I think that's frequently overlooked is subscriptions. Under FOIA, if there is a regularly created document, you can send a FOIA request, a subscription request that's good for up to 6 months. So if it's something that comes out every other week or once a month, you don't have to do 6 or 12 FOIA requests. You can do a subscription and it can be renewed. And that should often help you to get the information more quickly, right? There's some public bodies that play some tricks with that, but that's the first thing. The second thing is, in your request, you should give a dollar amount. If my request will result in a charge of more than $25, please contact me, right? Because that way it sort of forces a dialogue early on that hopefully will help you, if your request is too broad, that you can narrow it. And broad requests are a bad idea. They just are. You are much better off if you're you're not sure what you're looking for. It's much better to make it as narrow as possible to see what you get, right? To be educated on what sort of records they have, and then you can follow up. And the narrow tip is particularly important with emails. if you request all emails on a topic for 6 months, you'll be lucky if you get a bill that's less than $5,000. I mean, it's just the way that it currently works. So those would be the things that I think should be at the top of your priority list.
Can you set it up to where, well, you did address the idea of setting a maximum spending. What about notifying the FOIA requester how much it's going to cost first? What kind of boat are you getting yourself into?
They are required to notify you of the cost, right? But sometimes they don't. I mean, they're required to notify you of the cost, especially if they're requiring a deposit, right? But as with, I mean, we could tell war stories for several hours. I mean, a lot of those requirements are ignored. So you need to take as much control as you can up front and specify the amount so that you're hopefully forcing them to have that sort of dialogue.
Michael?
Yeah, I would say knowledge of the law is a very good tool. If you know what the law allows them to withhold or what it requires them to turn over, you can call BS occasionally when an agency is reluctant to turn over a document. And you know, that certainly happened to me where a records officer or a records coordinator will say, well, we're not going to give you that because of X reason. And my response might be, well, that's not in the law, so go ahead and give it to us. And then their next step is to turn it over. So knowing what the law says is important. The law also provides for an appeal. So if you're denied a record, you can appeal that, and that has to go and be reviewed by someone other than the public employee who turned you down. I would say when you're looking for records, as Robin said, be specific. Unless you're casting a wide net for a reason and telling the records officer exactly what you're wanting to compromise the investigation or the search that you're doing, if you can refine your request, it serves you well to do so. It helps the records officer to know, or the records coordinator to know what they're looking for, and it certainly speeds up the response time. So using Robin's example, instead of saying, I want all emails for a 6-month period for your entire agency, which I've seen those kinds of requests, good luck. Tell them what you want. I want the emails that went between this person and this person during this date period that contained the word, I don't know, I'm blanking on a word, but contain the word X. Give them specifics, and then they can run a search on those parameters and turn up records a whole lot quicker. And then I'd also say just common courtesy goes a long way. You have to remember the person you're requesting records from is a human being, and they're inundated with what they may view as unreasonable requests and hassles all day long. And that may not be a fair characterization of how they're viewing people, but that's the way it may appear. And so if you can be kind, if you can say, hey, here's what I'm looking for, let me start a dialogue with you, that goes a long way. When you get what you want, if you get it in a timely fashion, thank them. When you go back to that records coordinator for a second request, they'll remember you because they don't get much of that.
Yeah, and I think you touch on the personal relationships angle that we discussed earlier. Miriam, let me just add a little something on top of all that with regards to, is it in the law that all requests can be made through email? And what if you hear, no, you need to come out to, say, the courthouse in Sutton's Bay or near Sutton's Bay to make that in person?
No, you can request by email, but conversely, I mean, you point out something that I think is important. You can also go look at records, right? So one of your options under FOIA is to say, you know what, I can't pay for you to copy 5,000 pages. I would like to come to your agency, and under FOIA, you're allowed to do that, to go and look at the records on site. we often have trouble with that because they say, well, we have to redact them, and so we're still going to charge you to redact them. But especially if you're dealing with something that doesn't need to be redacted, that can be a really good and inexpensive option to go and look at those records. There's a lot of resistance to making them available, but that is an option under the law. Just a couple things to build on what was already said. Cannot emphasize enough how important it is to follow up and clarify what it is that what you're asking for, and to be specific. You got to remember that you're not limited to one request, right? So you can ask something really narrow, and I often do this. Ask something narrow to begin with. You get some documents back, and that leads you someplace else. You now see you've got this policy that shows this and that and the other, and then you have the terminology and the language that you need for a follow-up request that's going to get you additional documentation. Have a narrow calendar time frame. Put in that request how much you're willing, if it's going to be more, as Robin said. I had a situation where I had put that in, they sent me a bunch of documents, they sent me a huge bill, and I said, well, here's my letter, and it said you got to contact me if it's going to be more than $50, so I'll pay you $50, but I'm not paying your full bill, and they had to do that because I had made it very, very clear to them. The other thing is, if you get a huge bill, one of the things I often do, my FOIA requests often have multiple parts to them. I'm looking for policies and procedures on this topic, and then the emails and whatever. And I'll say, well, can you break down for me how much each of these is going to cost? Because then I can figure out what it is that's most important to me. Where is the expense? Because usually the expense is in one or two items. They got to program something to pull those items up or something like that. So breaking it down and saying, can you tell me of A through F, how much are each of them going to cost? And then I can decide what I really want to pay, what's most important to me.
I want to just follow up quickly because this was something else that also came out of the discussion on the radio this morning, that with regards to going and just looking at documents, that they do have to afford you that ability and also not rush you, that you may have enough time, this is true, to look over as much as you want. Michael, I think it's interesting to talk about the idea of redaction. We could all get reaction from all of you. What information gets redacted? If we're seeking information, why can't we see it all?
Well, let me show you what redaction looks like. I'm glad I saved this.
Yep.
We filed a records request with Michigan State for a variety of things, and we got back an email, and they gave us the top of the email. You had two from date of sent, sent date, and so on. And then this is what redaction looks like. It's a fancy word for a black marker. And then the other one, which I got in a different state, in a different context, so it's not Michigan's fault, but the Office of the Governor from the state of Washington sent me this confidential memorandum. It was 7 pages of black ink. And I actually followed up with that person and said, thank you for the prop. I'm going to use that the rest of my life. What agencies can withhold it's spelled out in the law. I think it's section 13 that says there are several reasons why an agency can withhold information. If they can withhold a portion of the information, but other parts of the record are still disclosable, that's when they do the redaction. So let's say that an email contains information that you're entitled to get, but it also contains a social security number. Well, there may be justification for redacting that social security number, but then giving you the rest of the email. Now, it probably shouldn't look like this. Maybe it's just one black line instead of 15, but that's what the redactions look like. If they're going to withhold information, they have to rely on an exception that's in the law, and they have to tell you what that is that applies in that particular situation.
Yeah, and once again, this might be something that's better suited for an attorney who has experience in all this. What does that say for the rest of us who don't maybe know the law that intricately and knowing what can be redacted and what can and what we're entitled to?
Right, I think what you do if you get something back that's redacted, there's the sort of common sense test, right? If it looks like they've redacted the social security number, that's probably fine. If it looked like they've redacted a police officer's home address, yes, those are the sorts of things that the government can redact. If you think though that what's behind that black marker, which you can't see, so you don't know what's behind it, but if you think it might be, then I'd encourage you to look at the law and look at those exceptions. One of the areas that we see a lot is there's an exception that says an unwarranted invasion of personal privacy. Now, some of us think the government is doing a lot of that itself. So we're not sure that our FOIA requests are the source of the unwarranted invasions of personal privacy. But that is an exception that sort of can swallow the rule, right? Because I'm not exactly sure how you define that, but that's an area where, and a lot of these exemptions have been litigated if the information is something that's really critical. But as a practical matter, it's very difficult to do, and it's easier to do what Michael suggested, which is to call back and say, it looks to me like what you're redacted is something that I should, can you explain to me which of the exemptions you're relying on, that kind of thing, and sort of try to figure out whether what exemption they're relying on and whether they actually have a basis for keeping it back.
You have to ask, or they have to give you?
They should tell you, but that's not
Under the
my
law.
experience.
Yeah, I mean, and one of the difficulties is actually, although they are supposed to, they're supposed to tell you the exemptions that apply to the redactions, but actually, they can, if you were to sue them, they can add other ones later. And one of the disadvantages is we don't know what the documents contain, right? So it's very difficult to assess sometimes whether or not information is improperly being withheld because we don't know what's underlying it, and they might give you a laundry list of reasons. But there are some where your BS detector will go off automatically, and that's when you want to have a dialogue.
Let's talk to you just a moment about good stories and things, the way FOIA has worked, good stories that you can enlighten us with. We'll start once again from the left and work our way this way.
Sure. So I think, we recently did a report, and it's available on the ACLU's website, on automatic license plate recognition technology. And for those of you who are not familiar with this, these are cameras that are used by law enforcement typically to photograph your license plate. They're either in a cruiser or they're stationary, and they capture a lot more data than an individual law enforcement officer could possibly ever do in a shift, and they have a valid law enforcement purpose. But our concern has been that this technology, a lot of these, if you know where my license plate has been, for the last 6 months, you can paint a pretty accurate picture of, what doctors I see, where I go to church or not, whether my kids play softball or they're in ballet. I mean, the government doesn't need to know all of that about me. So one of the things that we did is, as a national organization, we sent 600 coordinated FOIA requests to around the country to law enforcement agencies. And what that disclosed was really interesting because we saw just, vast discrepancies around the country. So, for example, there's a little town in California that has about 40,000 people, and they keep their records indefinitely, and they have 2 million records on file, license plate records, and so they can paint a pretty accurate picture of where the people in that town have been all the time. Whereas the entire state of Minnesota, they keep those records for 48 hours, and they have 20,000 records, right? So huge, because they erase them, they keep them for 48 hours, and then if there's a hot plate, it's a stolen car, or they're looking for somebody that doesn't, they'll keep that information. But for the rest of us, we're just going about our business, they erase those records. And one of the things that was really useful by doing these requests around the country is just to see the really broad range of how different governments respond to use a new technology, and to be able to develop model policies, and to say, look, if Minnesota can do that, is doing fine keeping these records for 48 hours, why do the rest of you need to keep them indefinitely and know all this personal information about us? And so that's an example of where FOIA really worked well and has produced a lot of information, comparative information that we hope will really inform the debate about that technology going forward.
A lot of, if you're reading the newspaper, the next couple of weeks, a lot of the investigative stories that you read will often include the phrase, according to records obtained by X newspaper. that's probably a records request. So a lot of good things get exposed through that mechanism. Mackinac Center relies on public records requests for a couple of tools that we provide the public free of charge. And they're in the forms of databases. We do a lot of with school districts for whatever reason. You know, a lot of attention in communities is focused on school districts and school spending. It's a big deal. And so we publish databases that contain the collective bargaining agreements between unions and school districts. We publish a database of superintendent compensation. So if you want to know how much your superintendent makes, you can go and find out. And we, you know, unintentionally, I know we've caused at least one resignation from a highly paid superintendent whose community really was outraged that she was making that much. It wasn't our intent, but that's the response that you see with those kinds of tools. My favorite story, though, is from out of state. I used to work in Washington State and worked for a think tank there. And we were noticing a problem that you've probably seen if you've attended a board meeting or a city council meeting. Your board members are up on the dais doing this on their iPads, their laptops, you know, just typing away. And during public testimony and debate, discussion, their heads are down the entire time and they're not looking up at what's going on. So we filed a records request with about 10 different councils, you know, commissions, councils, and we confined, this was an instance where we refined our request down. We wanted records that, or communication that was sent from or to council members during the times of public meetings. So we stated the dates, we stated the meeting times, and we said, you know, for instance, today we'd say August 1st, 6 to 8, we want all their communication. And we got back a lot of stuff that we thought was interesting because there's a little bit of horse trading that goes on. You know, hey, what are you going to do on this bill? How are you going to vote on this next motion? If I say yes, will you say no to the next thing? And we wanted to see some of that. One of the things we didn't expect to see were the racy emails between a city council member and his girlfriend who was sitting in the crowd during the public city meetings. And that information came to us, pages and pages of stuff that you would not want to read. And you know, we decided our organization did not release that information just out of respect to the individual who was not an elected official who was involved in that communication. But a local reporter heard about that story and filed a records request, and he published the story. And so it all came out. And it wasn't the fact that there's this period interest in seeing, you know, what kind of communication goes on between elected officials, who really cares? But the fact that it was happening with taxpayer resources, on a taxpayer computer, during public meetings, that was enough to get him unelected the next election.
And Mike's story is a good segue to my one-word response, Kwame, right? Although most people think that, you know, it's text messages and boy, it really wasn't. I mean, what ultimately brought him down was the settlement agreement that they tried to hide from the free press and the news, and that's what resulted in a number of other officials, including a city attorney, being sanctioned, because those records, the agreements, and the chronology of events demonstrated that the judge that had heard that whistleblower case involving Gary Brown had been lied to, right, by the parties. And that is a prime example of why Freedom of Information Act was enacted to begin with. These are post-Watergate statutes, and they were meant as mechanisms to try and prevent, you know, another Watergate from happening.
Doesn't work, does it?
I'm interested because of smartphones and almost everyone has them now, at least everyone texts. What about from the ACLU's perspective, how much is an elected official who's on his own personal device communicating, and how much intrusion can go into that person's life on his own private device?
Well, I mean, there's a Court of Appeals opinion from 2010 that says essentially if you're using personal email, that's not subject to FOIA. So I don't know exactly how the courts would translate that. I mean, you probably
There's
have
a,
better
there's a
idea.
there's a recent Illinois case. I mean, here's the, I think here's the bottom line, but we don't have a definitive decision in Michigan. The bottom line is you cannot conduct official business, right, through personal devices in an effort to avoid FOIA. You can't do that. Now, the difficulty is finding that out, right? And getting access to that information. Interestingly, I had a case in Petoskey a couple of years ago where there were individuals, public officials, that were exchanging emails, some on an official account and others not. And then never even came up as a defense. It was accepted that they were public records. But it really depends on whether or not they are conducting official business and whether or not the device or the account, whose property is it and who's accumulating the information. So for example, there is a big case a few years ago that addressed privacy in a different setting, but essentially police officer. And the way that I think it was a pager actually, that the way that it worked is you got so many and then you had to pay over that. And so there were reports that were generated, right, as a result of that were in the possession of the police agency. And through that, they determined that 2 officers were having an affair, which was a disciplinary type offense. So all those, it's pretty fact specific, Vic, on what sort of device, what's going on, and who has the information.
Is it the opinion of the panel that those types of issues, especially with Michael's story, are fair game? If you stumble upon something else that you weren't necessarily looking for, is that regarded as fair game?
Well, I guess from a press association, absolutely. I mean, you don't know what you're going to find with a lot of records requests. That's why we're able to file them. If you knew it was in the records, why file the records request? And I would say on the question of devices and technology, this is an area where we're going to have to figure out how to catch the law up to technology. Because let's say a school board has a Facebook page or a Twitter account. Well, there are some laws that deal with retention of records, but if they're putting out a tweet or a Facebook post, is that a public record? And if I wanted to see the comments for a previous post, could I do a records request and find that? Well, I'm not sure. Or let's say it's a city-issued cell phone that they're doing text messages on. Does the phone company keep a record of the text messages? Most of the time, you can't get that information. So that's where we're going to need to devise solutions to emerging technology. I mean, one answer with text messages is that you create an email account that automatically gets a copy of every text message that's sent back and forth. And that way you have a physical record saved on a government server. But yeah, there's definitely need for updates there.
I believe it was the general who got in trouble in Afghanistan, and they found out that he was not necessarily sending emails, but stashing it in the draft box, and both parties had access to it. Would that be covered under, I want any and all mail emails sent between people? Does that really necessarily mean that I've sent it to somebody if we have the implied decision that we're not going to send it back and forth, but just leave it in a draft or a value? Is all of that fair?
Well, with Petraeus, I mean, they thought they were being clever and cute, but they were really kind of dumb in lots of ways. Certainly, I mean, I would certainly argue that those were subject to FOIA, let's just say under Michigan law, because he was a government official at the time. She was doing a biography. She was accompanying him on government business and all that sort of thing. I don't want to get in the weeds too much, but here's part of the problem. The general rule is that if your emails are less than 6 months old, the government has to go to a judge and get a search warrant for them. They have to show probable cause, right, which is a fairly high standard. And in most places, but fortunately not in the Sixth Circuit, If they're older than 6 months, then they're deemed abandoned. So all they need is a subpoena, which is a much lower standard. So a lot of this depends on where you are, and I don't think that there's any distinction at all between drafts and copies and sents and all that kind of stuff. It's whatever is in the server, and I would never recommend that you say sent. You know, if you went to a public body and said, I want all emails that Mike sent to Miriam, I would say, no, all emails between them, right? You don't want to, you got to look at your language.
Right. Miriam, let me just start with, I think a couple, 3-4 years ago, here in Traverse City, there was a rather embarrassing moment for the school board where there was a FOIA request for any and all the emails sent between school board members from private home computers, where perhaps the goal was not met, but there were some embarrassing things that were said and made it in the paper, and that led to something else. As far as intrusion, is the ACLU concerned about that as the possibility of a misuse?
Well, I think that FOIA says that, it exempts, as I mentioned before, information of a personal nature and public disclosure of the information would constitute a clearly unwarranted invasion of an individual's privacy. And so, and that's a case-by-case determination based on the facts. And I think that the larger public policy question, there's individual questions about whether particular emails are too personal or something like that, or they're not really about government business. But there's, I think, the larger question as government is as new technologies emerge and government has more and more information about us, whether it's metadata about our cell phones, whether it's license plate tracking and knowing where our vehicles have been. As government has this, we want government to be open about what government is doing, but government's also collecting information on all of us. And I'm not comfortable with government sharing the information it collects about me with the public either. And so, I have a problem with the government collecting that information to begin with, but that I don't say the horse is out of the barn because we're still trying to keep the horse in the barn, but to the extent that government is keeping that kind of data, that's, I think, the really larger public policy question is what's going to happen with personal information that government has about all of us in terms of sharing. You see DNA databases now. There's been a real expansion of DNA databases for people who are arrested, not necessarily convicted. Lots of people get arrested, never convicted. Their DNA is now going to be in a database. Those kinds of things. And so there's a lot of concern about that information and where that's going to end up.
Let's talk a little bit just about possible abuses. What is bad about FOIA that isn't working? And then we can sort of transition to what do we do down the road and what can lawmakers do. But Michael, let's start with what is bad about FOIA. And I suppose that would be a lengthy answer, but
yeah, well, you've heard some of the stories and concerns already. I think the cost issue is a significant one. If you are certain that you need a record or that there's a story and you want to pursue it, but you don't have the budget of a newspaper behind you or an advocacy group, what do you do with a $100 bill? What do you do with a $6.8 million bill? Those are very real concerns, and I think that's something that's currently being dealt with. The other is just an agency's refusal to respond to a request in general. I think the law needs better teeth that would incentivize agencies to respond quickly and appropriately. If there were a per-day penalty that started to mount up for every day they withheld a record, or if the fees that they could recover were being reduced as 4001 does, that might incentivize agencies to respond quicker. Those are the issues that we encounter more often than others. And then the last thing I'll mention is just the private, the breadth of some of these exemptions might need to be trimmed down a little bit. The privacy one is real, and I think that the ACLU and Mackinac Center agree almost completely on what kinds of information should be shared of a private nature. But what is the limitation on privacy? Perhaps we don't need to know the details of a public employee's sexual orientation or the medical conditions that they have, which would be information that could be contained in a public record. But maybe we want to know that they're knocking off of work a little early to go and have an affair. Now that's private. Is it exempt from disclosure? Probably not, but those are the kinds of things that, when we talk about privacy, it just doesn't mean that all the personal information that's contained in the record gets excised out. There are limitations on that.
Let me add on top of that a question about, because it came up in a discussion this morning, maybe a graduated fine scale where first time okay, second time you're fined $200, third time you really get the book thrown at you. Is that even plausible? Let's start here.
Well, I think that there are a couple of responses. First, in the FOIA reform bill, currently, if there's an arbitrary and capricious denial, there's a punitive fine of $500. The reform bill would allow, under some circumstances, up to $5,000. The problem with that, I alluded to earlier when I say a judge has got to decide to impose that against them. You got to spend money to get in front of the judge. And a lot of times those, it's the judge's county. It might even be out of the same budget as her budget. So that may help with some, but I think the best fine is not reelecting people, right? That if all of us tell our elected officials, we expect you to be knowledgeable, and when they're being, when they're campaigning, what do you know about Open Meetings Act? What do you know about FOIA? Have you been educated on it? What's your position on that? I, as a taxpayer and citizen, want compliance. I expect these records to be open. I think that will have a much better overall effect. We'll still have problems, but one of probably the biggest problem right now is that the public bodies that are not complying with the Freedom of Information Act or the Open Meetings Act are doing so knowing that the chances are like this, that someone's going to haul them into court and that the judge is going to throw the book at them. That's the biggest problem.
From the ACLU of Michigan's point of view, what is the state of FOIA in the state? You stated too many times there. But what is the current status from your point of view? Is the battle being won? Is the battle being lost? Is it a tie? If that even makes sense.
I would agree with Robert that the chances of anyone, there is very widespread non-compliance or evasion of FOIA. Evasion is probably more the accurate term, right? So they turn over something, they turn it over late, they redact it, they charge you an arm and a leg when they really shouldn't be. FOIA already says it's supposed to be, I can't remember exactly what I'm saying, the actual costs.
Incremental.
Costs of but you get FOIA requests where they say it's $10 a page. Well, that's, I don't know where they're getting their photocopies made, but they're certainly not shopping around for the best bargain, right? And so I think that, am I glad we have FOIA? Absolutely. It's better than not having FOIA, and it's a really critical piece of holding government accountable. But I do think that there's some very significant problems, and we talked about those. The four things that I sort of see as central. First of all, the cost issues, the not turning over records, when they actually exist, and we know they exist, but they're just not turned over. The exorbitant fees, the misuse of exemptions, which I mentioned earlier, and then timeliness. FOIA it says you're supposed to turn over records in 5 days. I have never received a FOIA response where they did not invoke. There's a 10-day extension that you can ask, that you can invoke. I have never, ever gotten a FOIA response in 5 days, which is what the statute says. And many of them don't come back in 15 days. They come back months or something like that. And so those are the sort of four areas where I really feel that reform is necessary.
It's interesting because I did make a FOIA request probably 2 years ago, and I actually got with my information the amount that I owed. It was an insignificant amount that I could find no way to pay it. The information, so I figured, well, okay, I'll wait for you to get back to me. Let's just wrap this part of the discussion up with this question for all three of you. Is state or national security a good enough argument to deny information? And that's been one of the big arguments currently, is that, no, we're doing this, and I guess Snowden just released some information that says the government is really able to look into chat messages and things of this nature. Is that enough of an argument to say, we are protecting you, we need to do this?
No. You know, school board, what do they have that is national security that they can't share with me? What does the Register of Deeds have that's national security that they can't share with me? That sort of information is specifically exempt under FOIA, and I will tell you that in 20 years of doing this, I've had it invoked once. To me, that, to the degree that someone's pitching that as a reason for denying, that's not the reality of the exemptions that they're invoking.
Yeah, I agree. But 10 years of doing this, I've had it invoked once too, and actually I agreed with the instance where they invoked it. I had requested video cameras of a state ferry system, ferry boats that were moving people that was run by a state, and they denied my request for the security cameras inside the pilot's cockpit. And at the end of the day, I said, that's probably legit, but no. There needs to be a specific reason for why they would withhold that.
We do see it invoked actually quite a lot, mainly the national ACLU, because we do a lot of work on privacy and national security, and we have a project on that. And we've been litigating that issue in FOIA litigation, because although there certainly are things that government should keep private, and that are national security, it has become a blanket exemption. It has been, we're just not turning anything over. And I think what you see with some of the WikiLeaks releases, the Snowden releases, there may be things in there that legitimately should not have been released, but there's also a ton of classified information that shouldn't be classified, because it's not really classified. It's not really that secret. You see things, declassified that are court opinions that were public opinions, or newspaper articles that are now stamped classified that were produced. I mean, it's ridiculous, the stuff that becomes classified. And so we have to really, do we need security? Absolutely, but we also need liberty, and there's a way to have both if we're thoughtful about how we develop these policies and we respect both of those values.
Can I just give a quick plug in? James Goodale, who represented the New York Times in the Pentagon paper case, just had a book out, and it's very interesting because he at one time worked for the government and was a coder for Top Secret and stuff like that, and it's hysterical what he coded and why he coded it that, and that it's very informative, so I recommend it to you. If you just look up James Goodale, Goodale, in the last 6 months, you'll find it.
One quick question for Michael, then we'll open up for Q&A. I'm interested in the redacted letter you got, which is pretty much the entire. Did you ever get anywhere with a response to that?
No, I was requesting, this was from the governor's office in Washington. Now, in Michigan, the governor's office is not subject to FOIA, which is maybe one of the reforms that we can talk about. Why do you have an entire branch of the government not subject to an accountability law? But this document here was related to judicial appointments and whether or not a particular candidate should be appointed to a court of appeals. I never got the information.
I'm interested, and I'll be the first one for Q&A. Why is the governor's office exempt from FOIA?
That's the way the law defines public agency. It explicitly says that the office of the governor and the office of the lieutenant governor are not considered public agencies for purposes of FOIA. And that keeps them out of the obligation to turn those records over.
Accountability for the people.
Right.
All right, ladies and gentlemen, I'm sure there are several questions. We'll go ahead right here in front. Yes.
I got stories. Thank you all very, very much. Very knowledgeable. Love the information you gave. I thought it was frank. And while Mike did say the FOIA thing is simple, I would disagree with that because of all the other things that came up later on that. And Vic, great moderator. The problems that we find, and it was touched upon when it comes to cost, not the cost of getting the information. And you all, the agencies you work with, have a lot more freedom than we do as individuals. But it's what you do with it when you get it We filed a FOIA request when we were suspicious of an elected official who seemed to be operating outside of the authority that she had. And so we started looking into background and uncovered a former job with another public municipality, and were able through FOIA to get a really damaging report on her. We published it, and you understand that, and actually, when we finally got to the Supreme Court, the Michigan Press Association did file an amicus curiae brief. But we lost in circuit court because we had a judge who didn't like, having these things exposed. We lost in the Court of Appeals. That one couldn't figure that out. But the thing is, the cost of getting there. And when we decided we wanted to go on, and this was, the facts are supposed to outweigh defamation. It was a defamation case. And we had the factual thing that we published. We just reproduced it and mailed it out. And it got through those two courts, got to Supreme Court, and so I'm shopping for appellate attorneys in Detroit among some of the best in the country, and they're telling me for $50,000, they're not even gonna look at it. What do people do? You have a lot more freedom in getting this stuff, but what does an individual have, and what can be done to change that? No answer?
Well, we did get some relief from the ACLU.
Yeah, I would say there are a lot of organizations that could come to your aid. ACLU, Mackinac Center.
They were too busy. We did appeal to them.
No, and I'll defend anyone in that situation because, organizational budgets are limited, obviously.
Sure.
But there's also a new organization that just started up, and they've been on a couple of panels with us, the Michigan Coalition for Open Government. And there are national funds, national foundations that make litigation grants to people who are in need of litigation resources. And so you can apply for those grants now through the Michigan Coalition for Open Government.
What is the flaw that allows this to go through like that? Because, the Press Association certainly knows, because they've got most of the law on this, to be able to publish something that is fact. We obtained it by FOIA, so how does it go that far?
Well, what you're talking about actually sounds like, I don't know the specifics of your situation, but there's another issue that's sort of related to this. It's called SLAP suits, strategic lawsuits against public participation. And basically, what happens is that someone will publish information, and typically it's a corporate entity. It doesn't necessarily have to be, but typically it's a corporate entity that doesn't want to be criticized. They will bring a lawsuit against, basically to shut people down from criticizing them, even though the information is truthful. There was one recently in Kalamazoo. Somebody had a bad experience with a car place, and he posted a blog about they only sold lemons or something like that, and they sued him. Right? He described his experience. And the reason that these companies do this is they want to shut. They don't care about the cost of litigation. They don't even care about winning the case. What they care about is shutting people down from criticism. And so, in addition to FOIA reform, we really need SLAP lawsuit reform. We get a ton of requests to handle SLAP cases, and we simply don't have the resources to handle them. We have so many requests for SLAP, for SLAP suits, and we take them very, very selectively just because there's so many of them. Again, litigation is not the answer. There really needs to be legislation around SLAP lawsuits to prevent this kind of thing from happening.
You nailed it. That's what this was. It was a public official that.
And look, defamation is highly specialized, and most courts don't see very many of those cases, and so it's tough for some of the judges to get the nuances. And one of the things that I find I can't understand why politicians and public officials have such thin skins. But I will give you a piece of hope amidst a trend that I've been seeing that's very troubling. I've had several individuals who have contacted me over the last year who have spoken at public meetings, and they've gotten retraction demands. There are people that said, you have stood up at this meeting, and they're public officials, and they said, you said bad things about me, and if you don't retract them, I'm gonna sue you. Which is horribly troubling for all sorts of reasons. But last year, there was a case in the Michigan Court of Appeals where an individual was sued by 2 members of, I think it was the city council, some sort of public body, and their attorney for defamation. And the Court of Appeals they wanted none of it, and they said, this is ridiculous. And they said, by the way, this is a frivolous lawsuit. This is trying to shut up a citizen from exercising their First Amendment rights. And we wish you would have asked for sanctions in a frivolous case because we would have given them to her.
Who were the judges of record?
I don't remember. I read way too many of those cases. But, I mean, you know, one of the things that you have to do is, I agree completely with Miriam. In 2011, there was an anti-SLAPP bill introduced in the Michigan legislature. It didn't go anywhere. But those are a couple of the things that you have to do. But that's a really tough road to hoe.
We saw one, I just to follow up very quickly, we saw one recently in the Grand Rapids area where a community organizer was working with tenants, and there was a tenant meeting, and the tenants were all complaining about this particular loss, this particular landlord. The landlord had actually sent someone in undercover to tape that meeting. Then, and you know, the organizer was talking about like the, you know, bad conditions and these units. They sent her a retraction demand and told her that if she did not retract what she had said, this is, you know, an organizing meeting, that they were going to sue her. That's what happens.
Let's go here in the middle.
I have 2 questions, one on the Open Meetings Act and one on FOIA. With respect to the Open Meeting Act, and taking the scenario that you gave earlier, where you have town council members up there on their personal devices communicating, or maybe from somebody in the audience communicating, would it be proper for a person at that meeting to stand up and object? Because if they're communicating about business, that's not part of the minutes, and it's not part of the Open Meetings Act. So would that be an appropriate objection?
Yes, I mean, but I want to give you a couple of related issues. First of all, the Attorney General's Open Meetings Act handbook says explicitly that communications, electronic communications between members of a public body are basically that would be a violation of the Open Meetings Act. But it doesn't talk about the public official and someone in the audience, right? Now, I spoke to the Michigan Association of School Boards a couple of years ago, and a couple of people there brought up an issue with me. One was that she was upset because people were accusing her of communicating when all she was doing was taking minutes, right, on the computer. That was her job. And another because he had an iPad, but that's where all their materials were. And I said, look, you just need to do this. You need to tell everyone, this is what I'm doing. I'm taking minutes. We have a policy that we're not going to communicate during a meeting electronically, and we follow it. So I would just hasten to add that I would urge you to ask questions about it and try and understand whether or not they might actually be doing something legitimate. And I wouldn't have a problem, you know, if I'm a member of a school board and one of my kids texts me and says, who's picking me up? I mean, none of us is going to object to them responding to their kids, so.
But you never know what the text messages are.
That's true.
And so it would seem to me a pre-meeting warning from somebody from the audience would put them on notice with respect to the possibility of anything being done in violation of the Attorney General's opinion. You know these township governments and these city councils in these small towns, there's a law there, but it's there. It's not in their heads, nor is it on the floor of the meeting.
Well, and the other thing that you could do is, after that meeting's over with, immediately walk over and hand them a records request for all the communication that occurred during the meeting. That's another warning shot.
May I follow up with
Yes,
the
go ahead, please.
As you know, Michigan statute is quite flexible on record retention policies for the local governments. Therefore, what experience have you had in FOIAing records retention policies from local township governments and/or getting a records retention index of the information that's maintained?
It's not something that I've done. I've never asked for an index either. I've used the state record retention guidelines to say, I bet you actually have this, otherwise we'll be forced to report that you're not following the state's retention policy, and that's had some success.
Is record retention a guideline of the state, or is it a law? Or is it flexible between townships or municipalities?
There are some specific requirements for certain types of records. Depending on the kind of records you're talking about, there may be a statute that says specifically you have to keep it for X number of years.
Yes, in the back.
If I can help, I think I can help this gentleman. My name is Patrick Lawson. I'm a private investigator and investigative reporter on the clip. I have actually requested from the state of Michigan the record retention schedules. You can get them through the state library, through a particular court, or the state library that handles the archives. Now, I will tell you, when I originally requested these 4 or 5 years ago, I got a great deal of grief. They told me it would cost several $1,000s for me to be able to get these. And I said, why is this? Well, it's in a computer system, and we have to translate that information into another format and give it to you X, Y, and Z. And I said, well, let me talk to the chief geek, because I happen to speak geek. And I got the chief geek, and he says, well, it's in Crystal Reports. So I said, oh, great, I got a copy of Crystal Report 7 here. You just generate me the feed. I got a CD with everything 2 days later, absolutely free of charge. Okay? There is a small, obscure state board here in Michigan called the State Administrative Board. It has 2 functions and 2 functions only. One, it approves bond offerings for municipalities that the state of Michigan has to kiss off approval on. And 2, it governs the record retention schedules of every state agency. And if they make a change in the record retention period, they have to go before the State Administrative Board to seek its official approval. I will tell you, I'm probably the only one here in this room who has ever attended any of these meetings.
It's everywhere. You're everywhere.
They are rubber stamp formalities. They last about 10 minutes unless they're doing a bond offering. In that case, they last 12. Okay? But they pass these, and you can get the record agendas. They'll put you on the schedule and take a look. Most of these record retention schedules are subject to state statute. Okay? However, I'll warn you, in the state of Michigan right now, there's a bill pending before the Michigan courts, or before the Michigan Senate and Michigan House right now, that would approve electronic filing systems for the courts. You have one here in Grand Traverse County right now. Under that bill, all of the statutory record-keeping requirements of the state of Michigan will be repealed. And the record retention periods for all court records will be solely at the whim of the Michigan Supreme Court with no review.
Oh, we're going to stop that. You know the bill?
So what was the software that you were talking about that you used?
It's called Crystal Reports. It's a very common software package. Well, it's common among businesses, not among ordinary folks. But Crystal Reports documents, the file formats, they can be changed to generate this stuff out in the form of a PDF form for you, a PDF report, or a Microsoft Word report. I mean, it's very versatile stuff. The problem that you run into with most of these state agencies, when you get these requests for, telling you it's going to cost thousands of dollars. Truth of the matter is most of these people who are responding to these information requests have no understanding at all of the information technology that's being used. And so they often just grab a number because they don't have a clue what it's going to cost. They think, oh, gee, we've got 50,000 pages in the database. It's going to cost you $50,000, $1 a page or something, for us to be able to convert that. In most cases, it's literally a matter of pennies of converting the data.
That's an interesting question. Just how much bluffing do you think is going on out there with regards to FOIA requests? Where they just say, well, it's going to cost you whatever.
Yeah, I think that certainly does occur. I mean, it's a way to forestall producing the records. If I file a records request and I'm told it's going to cost me $100,000, I don't really feel like following up on that. So, yeah, the exaggeration can certainly happen.
Jason?
Well, speaking of random numbers, you mentioned the Michigan State Police and 500,000 or 6.8 million, which obviously don't really jive well with the lowest paid clerical understanding under the FOIA law. Would it just be cheaper at that point just to sue them for the information and go into discovery right away?
Not if you hire Robin.
And I give lower rates to this sort of work. No, it's not cheaper. You know, just as an example, in front of when we had testimony in front of the House Oversight Committee, I think it was Hamtramck. Police chief said that part of the problem with videos is only his sergeants and lieutenants can review the videotapes to, you know, redact the information and edit them. I'm like, my 14-year-old could do it, and you could pay him $5 an hour, and he'd be thrilled. But yeah, there's all sorts of craziness that way.
Back, please.
Is there any sort of formula to determine those costs? I mean, these exorbitant costs, like you were saying, do they just pull some number out of the hat? Oh yeah, it'll cost $10,000. Is there some sort of, you know, can it be standardized in some way so people will have some sort of clue on what kind of fee they'll, you know, if there's a fee involved?
Well, right now, it's supposed to be the lowest paid hourly employee capable of performing the function, but it also includes their benefits, right? That goes into the calculation. The FOIA reform bill would take out the benefits portion. The problem is who is determining who the lowest paid employee is. So for example, for some school board records for one of my clients, they wanted some emails, and they have a laundry list of exemptions, and the only person that can review them is the superintendent, right? Even for attorney-client privilege. Why are they doing that? Even though the superintendent presumably does not have a law degree and does not know how to figure out what's attorney-client privilege, because they have outside counsel, and if it's an outside employee, then they don't get to recover for those labor costs. They have to be, if it's an independent contractor or an outside consultant or something like that, they don't get a charge for that. But the problem is there are games being played with it. So the FOIA reform bill would limit, you know, the per page cost and require much more information on, you know, a line item with respect to the cost, which many public bodies don't like, and it would exclude the benefits. So all of that should help lower the costs.
Thank you.
Just one add-on tip that kind of addresses this, and addresses this gentleman's question too. One of the things I've done for years when I've been trying to get records on government agencies is I find out who that geek is, who the programmer is in the information technology department of the agency, because they're going to be the ones ultimately who are going to be processing most of the response to your request. They'll dump out the raw data, and then they'll send it to some bureaucrat to review. All right. If you get a hold of the geek, you ask them, what format are these records kept in? You know, what software do you use? What formats do you keep the data? And you don't ask them about the contents of the records at all. You just want to know how they're kept and what kind of formats that they're in. And ask them something about the field layout of the records. So you've got some kind of an idea of what kind of information is there to begin with. One of the things I've learned over the years is nobody ever talks to the geeks. The bureaucrats keep them sealed off from the rest of the world. These guys work down in some dungeon, nobody ever hears from them. And when you actually show up and ask them some intelligent questions about, gee, what do you do? What do you do all day with your job? And how'd you get these databases and everything else? Man, they think you are their newest best friend, and they will tell you everything you want to know. And they will often dump out the records and give you free of charge just because they're so happy somebody's listening to them. Somebody's interested in it. And
But
it
you
works like
forgot
a
one
champ.
question to ask them, Pat, which is who signs your paycheck,
Did it
right?
Right.
Which is another question to ask them when you're having this nice conversation.
Sure.
I'm guessing there's a chance that you don't actually refer to them as geek when you talk to them.
No, I talk to
You like
them,
it?
Doug, I'm a geek. I talk to geeks as geeks. Geeks talk like geeks.
Geek and me.
Use the term with others.
Right here in the front.
On the subject here, 10 years ago, pretty much all your government entities, particularly when we're talking about emails and other digital communications for FOIA, had servers and they had their in-house geeks. And you could have a situation where information existed, but you must pass through people who may have a conflict of interest. in satisfying that information. Two things have happened. One is cloud computing. For example, an awful lot of those servers have gone away. They're literally outsourced. The public records keeping functions for governmental entities. And I'd like your comments on that as maybe having a better confidence of fulfilling a well-designed search parameters, search for emails. That would be one question. And then secondly, I'll comment later about some ways that you can keep the other side honest if you have what we call a marker email, something that fulfills clearly the stated parameters. So if they come back and the answer is no such thing exists, and then you have this thing, you have the key to a slam dunk judgment.
Yeah, on your second point, that email I held up earlier with all the lines redacted, we actually had a copy of that from another agency where none of it was withheld. And so occasionally that does happen. You ask two agencies for the same record, one gives it to you, one doesn't. I don't have it.
I guess I'm not sure on the cloud computing. Are you asking whether or not you think that the materials that are on the cloud are still subject to FOIA?
Oh, no.
Okay.
But the probability you're going to get a successful fulfillment of your search parameters.
I think that varies on, it varies with the public body that you're talking about, what their policies are and their IT staff. I mean, it amazes me what some public bodies are unable to do themselves. They just don't have the knowledge. They don't use technology in a way where they understand the records that they're creating and how to retrieve them. It's surprising.
Yes, sir. When you talk about the records, we always elected official in Elmwood Township, Leelanau County, but we also have county government. The records at the county level are so poor that to go into try and figure out what's been said is not normally in that record. You can buy a disc from them. In our township, $3, you got the disc of the whole meeting if you want it. And a few days later, they come up with the typed edition. But the big deal that I wanted to get to, I guess, in my question was this. Since the quality is so poor, you have to go outside there and investigate. Prior to the Republican State Convention, I wanted info on Shostak Brothers Cherryland Mall versus the Wells Fargo Bank. And God, I was getting stonewalled all over the place. I finally got to the local unit of government that mall happened to be in. God, I couldn't write fast enough. They're spilling their guts here. Look at it, go over it. So it was just a matter of if I had tried to FOIA something, I'd still be looking for it. And at our circuit court level, most of that was all electronic, with the exception of at a certain date, a lot of that stuff went back into archives. And I thought, well, I get enough of this stuff. I'm not going to go work the archives, but I'd still be in the archives right now looking up the old cases. But so much of it's electronic, and it didn't. I just had to know the court clerk and the number and go back and look at it.
Most veteran reporters will tell you that they don't start off with FOIA, right? They try and talk to people, informally. The problem with that is when they get stonewalled, they call me and say they won't give it to me. Did you send a FOIA request? Well, no. It's like, I can't do anything to help you until you invoke the process. But absolutely, go in and ask for information informally. I will tell you, I get a fair number of questions from citizens. Can they force me to do a FOIA request? Under the Michigan Constitution, you're entitled to certain financial information separate and apart from FOIA. So I think as a technical matter, right, you don't have to submit a FOIA request to get that. But let's be practical, right? And let's talk about accountability. You want your government to track the FOIA requests they receive and what their responses are and what the information is. If for no other reason, then you want to make sure that your taxpayer dollars to supply that person for that position are well spent. So even though I don't think in some circumstances a FOIA request is necessary, if your government requests it as part of their process, I say go for it, do it. Right?
And just to follow up on that, I mean, I think depending on your relationships with people, sometimes FOIA isn't the best, isn't the best approach. For example, in the follow-up to this automatic license plate reader report that we did at the national level, we want to work with some local governments that are using this technology to talk to them. There's one approach is to send them a request, look at the data they're keeping. Another approach is to say, send them a letter saying, here's our report, let's sit down and meet with you. In advance of that, would you mind sharing your document, your retention policy, how long are you keeping the license plate information that you're tracking? That's a friendlier approach that in terms of the conversation that we want to generate will hopefully be more productive. So FOIA isn't always the right tool depending on what you want to do. Sometimes, sometimes it's better just to go in, if you're a homeowner trying to find out about the road that they're going to build in the middle of your farm, you can go into the relevant office and say, I'm concerned about this, can you give me a copy of whatever the plans are? And then you may, if you don't get it, you can invoke FOIA, and as a practical matter, that's what you need to do. But sometimes there's actually faster and better ways to get information.
I'm just going to go in the back here.
When you are doing with informal requests for information versus filing a formal FOIA request, is it possible you get incomplete or inaccurate information versus a complete? Are they obligated to give you full, accurate, complete information with
in response to FOIA?
request?
Yes.
Because my concern by doing the informal route, if you had something important you were trying to research, was as an investigator you might be able to tell me, so they might omit certain documents that might
That's
be more
true.
recent
That's
or
a
something,
danger.
and you might want the whole picture. Is that not correct?
My experience has been is that government agencies are scrupulously honest. They give you everything you want.
Is that sarcastic?
No, I think the point of the informal request is one where we've heard from other panelists who are also journalists that have said when a certain party is in office, the best people to talk to are the people in the other party, because they will often tell you, well, you need to ask for this record, and that's the kind of informal communication we're talking about.
Right.
Yes, ma'am.
Can an elected official, can their documents be FOIA'd if they're using their own private email or a Facebook message? Like if they're talking to other council people or talking about village business, could that Facebook or a private email sent from their personal computer, not a work computer, be FOIA'd?
Yes, that would be my view.
And then I just have one other quick
But
question.
we would get really hyper technical. You'd
Right.
have to discuss it
And what would
because
stop them from deleting everything
there's-
before you
there's nothing
asked?
that would.
And my second question is regarding FOIA and OMA, is there any difference between tribal government versus state government in this?
Yes. You can't get it from the tribes themselves.
Don't deal with
You only with only the government agencies with whom they interact.
Thank you.
We're up on time, and a creature of time being a broadcaster. I'm interested if we can just, through a show of hands, how many of you here tonight feel that you're getting 100% of the story from local government? 75% of the story from local government. 50% of the story from local government, about half. Less than 50%, going down to 25% of the story?
5.
The fact of the matter is, most of them don't even know.
I can't get it.
Well,
And
mine
I'm
is
an
not the
elected official,
percentage,
should
but
be
it's
able
the
to walk
honesty
in and
level.
get it.
The honesty is.
A partial truth is a whole lot.
How many here, just by show of hands, quickly, attend commission meetings, county meetings, and different meetings on a fairly regular basis?
Good for you.
That's one of the things we talk about a lot, and be proactive in that sense. Ladies and gentlemen, thank you very much. How about a big round of applause for our I believe we have some refreshments and probably some middle of
Beer and hot dogs or what?